So, Assalamu alaikum, everyone, and welcome today to our webinar on with an immigration attorney. Today's session is going to focus on visa questions often faced by residency applicants. This is the sixth webinar in a series of webinars that the APPNA Advocacy Committee will be conducting throughout the year. We continue with APPNA's mission of promoting healthcare-related advocacy. My name is Dr. Samina Qureshi, and I chair the APPNA Advocacy Committee. Today, I am joined with Dr. Furqan Rizvi, who is a member of my committee as well. He will be moderating today's session. We are also honored to have a distinguished immigration attorney with us, Mr. Furqan Azhar, as well as our distinguished advisor of the Advocacy Committee, Dr. Muhammad Fateh Shahzad, as a panelist. But before we begin, I would be very honored and very pleased that our president of APPNA, Dr. Barbara Rao, has been kind enough to join us. So welcome, Dr. Barbara Rao. Thank you so much for gracing our webinar with your presence.
Thank you, Samina and Furqan and Fateh, and I think there is another Furqan here.
Yes.
So, but thank you, everybody. Really, when we start this journey every year, where a few people apply and they get matched into the residency program, the next anxiety is like, it's almost you're preparing like your children, would they get to first day of the school or not? And then all of us, president, secretary, all APPNA, we are all worried, okay, how to get them to school. So with, like Fateh and previously Khurram Sadiq and Kamran, they have helped every year. But I'm really thankful to Fateh. I was meeting somebody yesterday, Director General of Health from Pakistan, and she was saying like how effective Fateh is. Any problems, he's always there. So thank you for that. And obviously your team, Samina, now with Furqan, everybody else, I'm nobody to say that I'm really pleased, but APPNA is pleased that what you guys doing. So thank you, and please get started.
Thank you so much for the opportunity and for the platform. Thank you. Okay, so let's get started. So our moderator today, Dr. Furqan Rizvi, if you would kindly share your screen, and then we can get started without further delay with our immigration attorney, Mr. Furqan.
Thank you very much, Dr. Samina Qureshi. Thank you, everyone, for joining us. Assalamualaikum, and thank you, Dr. Fateh Shahzad, for joining us. He has been a wonderful resource for us over the last several years. And thank you, Dr. Barbara Rao, the president of APPNA, for joining us and giving us the platform. And thank you, Dr. Samina Qureshi, for taking the lead and coordinating with us. It's my honor to introduce Furqan Sani Azhar. He is a wonderful, fantastic attorney here based in North Dallas. I would like to introduce him. Attorney Furqan Azhar has been practicing U.S. immigration law for the last 20 years. His practice areas include business immigration, family immigration, investor visas, and refugee law. Furqan has successfully argued on appeal 2 published decisions, one by the Board of Immigration Appeals and the other by the Administrative Appeal Office. He frequently speaks on legal topics, has testified in criminal court as an expert witness, and has served as an adjunct professor of immigration law at Dallas College. From 2012 to 2014, he was the AILA Texas, Oklahoma, New Mexico Chapter Consumer Protection UPL coordinator. In September of 2019, the Dallas Bar Association's Immigration Law Section awarded Furqan the Immigration Excellence Award. Thank you, Furqan, for joining us, and you can take the stage.
Yeah, well, thanks for having me. Assalamu alaikum, everyone, and it's an honor to be here. And so I think this is super timely, and it's always relevant. So I don't want to take up too much of my time because I know we got to get through the presentation, and then I'm sure there's going to be a vibrant portion of questions. So let's get into it, right? So Dr. Furqan, if you don't mind sharing the presentation,
Sure.
We'll do this, and then we'll do a Q&A session.
Here you go.
All right, and then if we could go to the next slide, you're going to be doing a lot of like hitting enter because each bullet is separate. So can you put it in presentation mode? if you don't mind. Like if you go to the bottom right, there's a presentation mode option. There's like a, or yeah, if you go to view, you could also put it in presentation mode.
Let me just
No. Okay. Well, if you go all the way down to the bottom right, yeah, a little bit to the right. Yeah, next one over, next one over, next one over, right there. Yep. There you go. Slideshow. That's what it's called.
That's great.
All right. All right. So, first thing I wanted to talk about is the B visa, which I'm sure several of you have heard. That's going to be visitors. So, you can just keep hitting enter, Dr. Furqan, because I'll probably be going through this pretty quickly. So, the purpose of the B visa, generally, is for visitors for pleasure. It can include things like coming to the United States to visit a family member. It could be like somebody coming to be part of a funeral or testify in criminal court. But for today's purposes, it's going to primarily be around people who are foreign medical graduates are coming here for clinical observations, shadowing, or taking USMLE exams. Now, there are 3 requirements for the visit visa. The first requirement is that you have to have a purpose. Okay, so when you appear at the U.S. Embassy abroad, the consular official is going to ask you, what is the reason for your entry into the United States? So typically, if you're coming here for clinical observations or shadowing or taking USMLE exam, you need to have a letter of invitation, okay, from the healthcare institution, or if you're taking the USMLE exam, you need to have proof that you've registered for the exam, okay? So that's the first thing, is you have to have that letter of invitation, and they're going to want to review that, and the language of that letter is important as well. Secondly, you have to prove that you're not going to become a burden on the U.S. government. The technical term for that is public charge. So you want to ensure that the consular official does not believe that you will be coming to the United States and you will be asking the government for resources, because then you become inadmissible to the United States under Section 212 of the Immigration and Nationality Act. So the way to prove that is through your bank statements. So you want to make sure you bring at least 6 months of bank statements. Make sure they're in US dollar currency as well. So if they're in rupee currency, you want to make sure that your bank also provides a letter converting them to US dollar currency as well, because they're going to want to see that. And then third, and this is most important, you have to establish what's called non-immigrant intent, which is the intent to return back to your home country. And how do you establish non-immigrant intent? Well, the consular official will be looking at the totality of the evidence, and they'll be looking at things like property ties, employment ties, family ties, financial ties. So when I say property ties, what do I mean by that? That can include things like titles or deeds to land. When I say employment ties, what I mean is that if you're currently employed, you'd want a letter from your employer stating that you've been given a leave of absence to allow you to go to the United States to perform whatever you want to do in the United States. Family ties would include things like immediate family members and family members outside your immediate circle. So spouse, parents, children are all family members, and those are the most important family ties. And then when I say financial ties, I mean things like investments and bank accounts and stuff like that. So you want to document all of that and bring it. Now, the reality is that oftentimes the consular official has already made up their decision before you even walk up to the counter. And they may not even give you an opportunity to explain why you believe that you have non-immigrant intent. And they may just hand you the classic slip, which is the 214B slip, which says inability to establish non-immigrant intent. And so, unfortunately, you don't have a lot of recourse in that situation. There's no appeal mechanism. And so all you can really do is just reapply in the future. And so it can be a very frustrating process. Now, one thing I want to note here is that if you're coming to the United States as a visitor, you cannot receive payment. So you is working. All right. So if the letter of invitation states that you're receiving payment, that's problematic. And make sure that there's nothing in there that would indicate it. All right. And then the other thing I want to mention on the visit visa is that you might get a multiple entry visa. Usually it's just a single entry visa, but you might get a multiple entry visa. And if you get a multiple entry visa, Just because it's valid for a year or 5 years does not allow you to stay for that amount of time. When you arrive at the port of entry, you're going to get what's called an I-94. That's an arrival departure record. And that's usually going to grant you 6-month entry into the United States. And then in some certain situations, you can extend that for another 6 months. So there's a difference between the visa that's digitally imprinted into your passport and your I-94, which controls your status in the United States. All right, let's move on to the next slides, please. Okay, let's get into the J1 visa. All right, so the J1 visa is typically designed for people who are coming to the United States to engage in some sort of training program, cultural exchange oftentimes. For the purposes of the people on this who are viewing this panel, it's going to be people who are foreign medical graduates coming here to pursue a residency or fellowship, or sometimes research, clinical training, or research. Now, the training program may be 3 years, maybe 7 years. Typically 7 years is the max. And there are certain situations in which you can get an extension of the J1 beyond 7 years. If your Ministry of Health can prove that there's a significant need in your home country, you may be able to get, and you're pursuing a specialty, you may be able to get an extension beyond the 7 years. Now, one thing to keep in mind is that your J1 visa is controlled by your CVIS record. And so your CVIS record, your director, whoever the program director will be responsible for controlling your CVIS record. All right. So for the J1 visa, you want to make sure that you do have that contract, and that you've passed the necessary USMLE exams and demonstrate English proficiency, which is, I'm sure is not a problem for our Pakistani nationals. Now, this is really important. So now that you have been matched and it's time for you to go for the visa stamping interview, you'll want to make sure that your program provides you the DS 2019. That's a really important document. That document establishes that you've been admitted into the program, and that you're eligible for J1 visa stamping. Secondly, you'll have to complete a form, which many of you all are probably familiar with. It's called a DS-160 application. It's a non-immigrant visa application. It captures a lot of biographical information and residency information and employment information, and then it goes through a series of narrative questions that you have to answer yes or no to. You also have to pay a fee called the CVIS fee, which is usually about $150 or $200, and that's done online. You need a letter from the J1 program sponsor to present at the J1 at the interview. And a statement of need from your home country, which I think usually comes from the Ministry of Health. And again, most importantly, this is a purely non-immigrant visa. It's not a dual intent visa like the H-1B or the L-1, which are other types of visa. And we're going to talk about the H-1B visa as well. So it's a purely non-immigrant visa, which means you must be able to establish to the satisfaction of the immigration official that you have the intent to return back to your home country. So again, you have to provide the same things that we talked about: financial ties, employment ties, property ties, and family ties, that kind of stuff. Duration, 7 years, which is what we had talked about. And then, one really unique part of the J1 visa is that your spouse, who's on J2, can come with you if you're married, and the spouse gets work authorization. So he or she can apply for an EAD, employment authorization document, allowing them to work while you're pursuing your J1. That's an open work permit. So that actually allows them to work, wherever they would like. If they want to be self-employed, if they want to work for multiple employers, and there's nothing wrong with that. So that's one of the really cool parts of the J1 visa, which is not true for the B visa. Obviously, we talked about that. You can't work on the B visa. And on the H4, which is the dependent visa for H1B, under certain circumstances, your spouse can work. Let's move on to the next slide. Okay, so super important here. Now, the J1 visa, what attaches to the J1 visa is Section 212E of the Immigration Nationality Act, which is the 2-year home residency requirement. Super important. That attaches to any J1 visa when the person is a foreign medical graduate. Now, that 2-year home residency requirement attaches whether you complete your program or not. Okay, so if you enter the United States on a J1, stay here for a week, and you're like, nah, I'm good, I don't really like this, I'm going to go back to my home country, you still have a 2-year home residency requirement. So that's something to keep in mind. just because you didn't complete your program doesn't mean that that 212E doesn't attach to you. Now, the 2-year home residency requirement needs to be fulfilled in the aggregate, which means it's a cumulative test. So it's not as though you have to spend 2 years abroad continuously, but eventually you do have to meet those 2 years cumulatively. So it could be a year and then a break and then another year, and then you met the 2-year requirement. How do you know if you're subject to the 2-year home residency requirement? On the bottom of the visa, your J1 visa, there's going to be a notation which says that bearer is subject to section 212E, 2-year home residency requirement. And on the DS 2019 bottom left-hand corner, it will also mention there's a check mark, there's a checkbox, and it'll be ticked that you're subject to the 2-year home residency requirement. That DS 2019 is not always checkmarked. It may not be, and if it's not, and if you're confused whether you're subject to the 2-year home residency requirement, you can email the J1 visa waiver program and request an advisory opinion to ensure that you are subject to it, or perhaps you're not, but if you're a foreign medical graduate, almost certainly you are. If you could hit enter for the next bullet. Okay, could we go back one real quick? All right, so you cannot change your status. So what does that mean? If you enter on a J1, okay, and you're subject to the 2-year home residency requirement, and then let's say that you want to pursue an academic program. Let's say, for example, you wanted to pursue a PhD. You cannot change your status from within the United States from J1 to F1 because you're subject to the 2-year home residency requirement. Or let's say that your spouse wanted to pursue a visa and you wanted to pursue a dependent visa. Not possible. The only exception to that is going to be the O1. If you're an alien of outstanding ability, if you can establish to the satisfaction of USCIS that you have national or international recognition in your field, then you can pursue an O1. But otherwise, if it's any other type of non-immigrant visa, it's not going to happen. You're going to have to leave the United States and go for stamping. All right, so let's talk a little bit about what the different sort of waivers are, because there are some waivers that are eligible for the 2-year home residency requirement, and the one that's going to be most relevant to this group is going to be the Conrad 30. What does the Conrad 30 mean? Conrad 30 means that there are 30 waivers available for each state. And by the way, each state, they have their own requirements. So it's not as though like every state has that there's conformity among the states. That's not true. So each state has its own requirement. You're going to need to get a contract from the state for at least 3 years. And that means that you're going to be working likely in an underserved area or a rural area in an underserved population for at least 3 years. And what's going to happen is you're going to end up switching to H-1B if you can secure that Conrad 30 waiver. The other ones include things like interested government agencies. So, for example, if the Department of Health, the Department of Human Services, Department of Veterans Affairs, if they wanted to hire you, you can get a waiver that way. There's also a waiver for persecution, which is very similar to asylum. If you can prove that you would fear persecution from your home government because of your race, religion, nationality, political opinion, particular social group, you may be able to claim a waiver based on those grounds. In addition to that, the next one is going to be hardship. So let's say, for example, I actually do quite a bit of these. Let's say, for example, you came to the United States with your spouse on a J1 and J2, and then you gave birth to a child, and that child is a U.S. citizen. And let's say, for example, that child suffers from some sort of medical condition that requires ongoing medical treatment, then you may be able to get a waiver based on hardship. If you can prove that hardship is beyond the normal level of hardship that one would suffer if they were not allowed to stay in the United States. Let's say, for example, the medical treatment that's available in your home country is not available. The medical treatment available here in the United States is not available in your home country. Then you may be able to get a hardship waiver. And by the way, it's not just children. If you marry a U.S. citizen or a permanent resident, you may be able to claim hardship, or if perhaps one of your parents have permanent residency or U.S. citizenship. And the last one is no objection. No objection doesn't apply to international medical graduates, foreign medical graduates. So we can move on. But in other J1 situations, you can oftentimes get a no objection letter. All right. So let's talk about the H-1B visa, which I'm sure many of you all have heard about. when you are a foreign medical graduate and you get a waiver for the Conrad 30 and you're getting an H-1B visa, that's actually exempt from the cap. What do I mean by the cap? Well, there's only 65,000 H-1Bs available per year for bachelors and 20,000 for U.S. masters. That's 85,000 total. That's the cap. That's subject to the annual lottery, which is conducted in March of each year. However, there are some H-1B visas that are exempt from the annual cap. And so when you're working for an institution that is primarily engaged in research, or it's affiliated with a research institution that's nonprofit, then you're exempt from the cap. And typically these Conrad 30 waivers are always qualify as cap exempt. Again, you have to work in an underserved area, which is what we had talked about. So it's oftentimes a rural area, and you have to have the 3-year contract. Make sure that 3-year contract is in place, because the Conrad 30 program is going to want to see that contract fully executed. And then if you could just hit next on the, if you could hit enter on the keyboard. Let's talk about the $100,000 rule. Who does it apply to? So that applies to situations in which you are leaving the United States and you're going to be stamping abroad. So if you're stamping outside the United States, then the $100,000 fee will attach. When it doesn't attach to you is situations in which, for example, you're filing an amendment, an extension, a transfer, or a change of status inside the United States. So if you're here on J1 and you get the Conrad 30 waiver, and then you can change status to H-1B, the $100,000 rule does not apply to you. Does not apply to you. But if you're abroad and you've never had H-1B before, then it would apply to you. Other exceptions include things like if you're applying under the national, if your work is in the national interest, or if you have a valid H-1B visa that's already digitally imprinted into your passport, and you're abroad, then the $100,000 rule would not apply to you. I think that probably concludes my presentation, and most of it is very high level. I'm sure that several of you may have case-specific questions that you wanted to chat about, and so I'm happy to do that. I guess we can go ahead and segue into the Q&A portion at this point.
Yeah, so I'll just add, one second. So I'll just add, so this is the portion where you can take the maximum advantage. For any of you, the attendees, any questions that you have, please post it in the Q&A panel, and Dr. Furqan will then facilitate us from there. Go ahead, Dr. Furqan.
Yeah, thank you very much for the wonderful presentation, Furqan, and very educational as well. So I'll be waiting for the questions to come as we move on. I had a few questions that came up recently through the. Let me just pull it. Okay. Let me just. So the first question is from Bushra Rahman. Does 2-year rule also apply on paid research position on J1 visa? Furqan, please. Thank you.
Yeah. So not all J1s have the 2-year rule. Oftentimes, it's going to depend on whether or not the program was funded by the U.S. government or your home country. If you funded it entirely, then oftentimes the J1 visa will not attach. Again, you really need to look at the bottom of the J1 visa if there's a notation there, and you also have to look at the DS 2019. If none of those, if the bottom of the visa says the bearer is not subject to the 2-year home residency requirement, and your DS 2019 says not subject, then you're good to go. You can change your status and you're not subject to the 2-year home residency requirement. So to your question, Bushra, does it? It's not really possible for me to know with absolute certainty unless I know, where the funding comes from, because that's one of the critical components of whether or not, you're subject to the 2-year rule.
Thank you. Thank you, Furqan. So the next question is from Beza Kurt. The question is regarding observership, B1, B2 visa. What should I say in the visa interview if my long-term goal is residency in the USA?
Yeah, well, I mean, the purpose of the J1 is typically going to be for the residency.
It's a B1. It's a B1.
Sorry? Oh, B1. Oh, I see. Okay. Okay. So yeah, I mean, if you don't want to use the terms long term, you want to be able to convince the immigration officer that you intend to return back to your home country. So you would probably say something to the effect of, while I want to eventually maybe pursue a residency in the United States, my ultimate goal is to return back to the United States and practice not back to Pakistan and practice in Pakistan and serve the Pakistani people based on what I've learned in the United States. So there's nothing wrong with saying that you may perhaps pursue a residency in the United States in the future. Of course, you want to make sure that you couch that in terms that are speculative. In other words, it may or may not happen. And then if it does happen, then the ultimate goal would be to return back to the home country so that you can, use that information to serve your fellow citizens.
Yeah. So the next question is from Irshad. I previously attempted to enter the US on B1 B2 visa and was found inadmissible at the port of entry due to insufficient ties to my home country. I was allowed to voluntarily withdraw my application instead of being formally removed. Will this be considered a serious negative factor during consular processing for J1 research visa? Is there any risk of being denied under INA 214B again? And how can I reduce the risk? Should I disclose this incident in my DS-160, and how should I explain it?
So in the DS-160 application, there's a question that says, have you ever been denied a visa, refused a visa, or had your visa revoked? So you should disclose it on the DS-160 application, because what happened, this is a unique situation. Basically, this person, let's see, Aisha? Is this? No, not Aisha. This is Irshad. So Irshad says that his visa was approved by the U.S. Embassy abroad, and then he actually came to the United States, arrived at the port of entry, and then they denied him based on non-immigrant intent, even though he had already established that at the time of the visa interview, and they had granted him that. So that's very unique. I haven't heard a situation like that that I can remember. Anyways, back to your question. Do you have to? So Irshad was allowed to voluntarily withdraw the application as opposed to taking a removal order, which would have triggered a 5-year bar to reentry. So that's good. At least they allowed Irshad to do that. But anyways, back to your question, Irshad. Should you mention that on your DS-160? Yes, you should. How do you, will it negatively impact your J1 visa stamping in the future? It is something that they can view in their history. So it is probably going to be something that they're going to look at with a little bit more scrutiny, but it doesn't necessarily preclude you from applying for the J1 visa. You can still apply for the J1 visa, but they're going to be looking at your non-immigrant intent more closely. And again, those things, the non-immigrant intent section, you know what? I actually have a checklist of documents that would be helpful in terms of establishing non-immigrant intent. It's like 20 documents. So I'm going to share that with the group later on. That way you guys can see that, and it'll give you a good sense of what sort of documents may apply to you and what sort of documents may be helpful. But again, they're looking at the 4 ties that we talked about: family, employment, investments, financial investments, and property. So they're looking at those things, and then they're going to try and see whether or not the person can establish non-immigrant intent. Oftentimes my clients get denied in Islamabad, then they go to Karachi, then they get approved, or vice versa. So if you get denied in one of those consulates, then perhaps try applying in another consulate. A lot of times it's just the officer, it's the luck of the draw. Sometimes you just get a bad officer and then, you're cooked. And so it's just unfortunate. So sometimes the strongest applications get denied and the weakest applications get approved, and there's no rhyme or reason to it. So it's a very, very frustrating process.
Dr. Furqan, I would like to add a few things to this.
Yes, please, Dr. Fateh. Go ahead.
Sure. Mr. Furqan, this is becoming very common now, if not everybody, but quite a few. Like recently, one applicant, one visa holder was denied boarding in Istanbul. He was he got a visa, got from Lahore to Istanbul, then he was denied entry there because of inability to show ties. Very common in Abu Dhabi, because immigration happens in Abu Dhabi. Many students, many doctors have been denied. Recently, one, maybe it was Irshad, maybe it's somebody else, was denied entry in Chicago. He got to Chicago, so they asked him for secondary screening or secondary interview, and he was taken to the room. Meanwhile, they took his phone, which is very common thing. So you all need to be very careful what you have on your phone. So they looked into it takes only a few minutes to screen the whole phone. So they found that he was a part of a group who got their visas approved, and they were looking for job or opportunity in US when they get to there. Like they were a group of maybe 50, 100 people from all over the world, and they were asking question that, okay, when we get there, how can we find a job in restaurant? How can we find a job in a gas station type? So when they looked at, the officer looked at, and he said that you have this access, even though he did not ask that question. So he was asked to either withdraw his entry or he will be deported and banned for 5 years. So he went back. He called me from the airport, and I advised him to go back, because if they do forcefully remove you, then you will be banned for 5 years. So this is happening. Now, I did actually reach out to DHS about this question. So their response was that even though he did not ask that question in the group, but he has access, he has a knowledge that how he can find a job. So you guys need to be very careful when you travel to US these days, that your social media, your WhatsApp should be very clean about these things.
Excellent point. Yes,
Thank
and
you,
one
Dr.
thing. Yeah, sorry
Yes,
to cut
please
you
go
off.
ahead, Furkan. Go ahead.
I just wanted to say a few things on that, because I think that's a really good point, which is that when you're coming as a non-immigrant, you don't have constitutional rights just because you arrive at the airport. And so if you refuse to provide your phone, that is a basis to deny you entry into the United States. So it's not like you're a permanent resident or a U.S. citizen. And so the things on your phone will be used against you. And just like Dr. Fateh said, even if you didn't say anything in the chat, your just the fact that you were in the chat or your failure to say something can be used as a grounds to deny you entry into the United States. I'll give you another example. Several of my clients are are in chats that talk about the Palestinian issue, and sometimes people say things that are inflammatory. Sometimes people say things that are emotional. And those things can be viewed as anti-Semitic by the border official. And if you fail, and so I've had situations where the border official said, hey, this person so-and-so said this thing, and you didn't respond. You didn't say anything defending the United States. And that's a basis to deny you entry into the United States. So you have to be very careful. Clean your phone, bring a burner, whatever you got to do. Because even if it's facial recognition, or whether it's the code, they're gonna get into your phone, and they're gonna be able to see everything. Secondly, in Chicago, you always want to avoid Chicago. Chicago is notorious for denying people. So if you can avoid Chicago, definitely avoid Chicago. Any port of entry is going to be better than Chicago.
Thank you, Dr. Fateh Shahzad and Furkan, for the wonderful answer and explanation. The next question is from Mariam. Can J1 visa dependent stay with the J1 applicant during the waiver period, serving in underserved area?
Sure. Yeah, absolutely. When you say dependent, that is exclusive to spouse and children, though. It doesn't include parents. But yes, spouse and children can stay with the J1 visa applicant in the underserved area. The children age out once they turn 21, or if they get married, and then the spouse can stay with them for as long as the duration of the program. And again, the spouse is eligible for work authorization, though the children are not.
Thank you, Furkan. The next question is from Habib Mashuri. I match into residency program and I'm a J1 requiring candidate. I graduated 1.5 years ago, so I don't have PMDC license or house job, and technically can't work in Pakistan right now. Do I need to show home ties by showing current employment at the time of J1 interview?
It's not necessary for you to show employment. That's just one factor that the embassy official can consider. So if you're unemployed, or let's say, for example, you're a student or something like that, that's fine. But you still have to establish to the satisfaction of the consular official that you have non-immigrant intent through the other factors that we talked about. So it's not as though you have to meet all of those factors. That's not necessary. I'm just giving you examples of how to prove non-immigrant intent. And again, it's based on the totality of the evidence. And again, you might have very compelling evidence. It may still result in a denial, and you'll never know why. Because a lot of times those decisions are made behind closed doors. Not a lot of times, they're always made behind closed doors. And you might think that you have a great application, and then they'll deny you, and they'll never know why. They'll just shut the counter door and say next, and so then you'll just have to apply again.
Thank
I
you,
would
Furqan.
like to add,
Yes, Dr. Fateh, please go ahead, sir.
Dr. Sabina, you wanted to say something you want?
Yeah, I had a question that I think a few people have also repeatedly asked. What is a reasonable amount of funds to show in my bank statement for B1, B2 visa?
We go back to that explanation, then I will let Mr. Furqan. So about PMDC is that PMDC having a permanent license in Pakistan does have very importance, especially if you're coming for B1 or B1 based on step 3. Just consider yourself that step 3 is an exam, is a licensing exam. So if you don't have a license in your own country and you're going to go to another country to apply for a license, that's considered, the visa officer might not like it. And many visas been refused. I'm talking about B1, especially coming from step 3, which is a licensing exam, and you don't have your own license. Now regarding J1, because J1, especially the clinical, because it's a paid job, you're going to come here and work and you support yourself. So PMDC license or other ties are not as important as the for B1 and unpaid J1 research. Now, the response to your question specifically, if the visa officer does ask you a question, you don't have a license in Pakistan to practice. So your response in specifically this case, because he's coming for J1 and residency, after completing 1 year of residency, you're allowed to get PMDC license because the first year of residency is considered as a house job in Pakistan. So tell the officer that, yes, I did not do my house job. I don't have a permanent license, but as soon as I finish my first year of residency, I will apply for my for PMDC license. I will qualify for that. So that should help you out.
Yeah. Awesome. Yeah. That's a great answer. And then Samina, you had asked about that, the amount of funds that are necessary for visit visa. So it's not a bright line test that I can give you. And the reason that it's not a bright line test, because it depends on how long you're staying, and it also depends on how many family members are coming with you. And so the government is going to be looking at the poverty guidelines. That's on form I-864P. And so again, it's going to the poverty guidelines will dictate how much is. So I'll give you some examples. Let's say, for example, you're just coming by yourself, and you are coming for 3 months. So the poverty guidelines for a family of 1 are usually like around probably about $22,000. And so you would divide that by 4, and then you're looking at about 5 or 6K. And then you would probably just want to like double that, just to be on the safe side. So if you're coming for 3 months, I would probably suggest anywhere between 10 to 15K at a minimum. And so the more money you provide, of course, the stronger your case becomes. But again, I can't really say with absolute certainty, this is the amount, because it depends on several factors, including, like I said, how long you'll be staying and how many family members are going to be coming with you, because they'll be looking at that and they'll be comparing that with the poverty guidelines.
Yeah.
Thank
And
you.
also, if you have a family member here, any friend that you're going to stay with, that will also reduce your expenses. So all those factors will be considered. So you have a return ticket, you should have it if you're coming for B1. And if you have a family member, a relative, or a friend that you're going to stay, get a letter from them that I'll be staying with my friend, so it will not cost me money for accommodation and even food. So consider all those factors when you show your bank statement, and bank statement can be yours or can be anybody in your family who will have a letter or affidavit that I will sponsor, or I will provide some financial support to my son, my daughter, my brother, whatever. And that person can be either in Pakistan or even any other country, as long as they have proof of income, showing statement that they have enough funds, and a letter, affidavit type of letter, that I will be supporting this person. That should be good enough, because most of you might not have enough funds in your own account.
Dr. Fateh Shahzad, and thank you, Furqan. And we are getting a lot of messages of thank you and appreciation for both of you. The next question is from Aisha Salam. I was recently granted a single entry annotated B1, B2 visa for observership in the US with the annotation listing a specific hospital and state. My question is, during the same visit and within the authorized stay, would it be permissible to undertake an additional observership at another hospital if I present invitation letters to the CBP officer? The observership would be purely observational in nature. Also, could doing this cause any issue with future visa applications?
So I think Dr. Fateh and I are in agreement here, because I saw him shaking his head. The answer would be no. You want to comply with the terms of the visa. And if you don't do that, the immigration officer will say you were granted this visa under these conditions, and you took the liberty to then go beyond that, and that's definitely going to be viewed as a negative factor, and it's something that you should avoid. Not avoid, but you should just not do.
Yeah, last year from Pakistan, various J1 visa was denied because of this reason. And India, around 270 visas were denied, J1. Singapore, Sri Lanka, many countries visas were denied because people did not honor their request in DS-160 and the annotation. I've sent Dr. Furqan some annotation if anybody wants to look at. They're all specific, that where you're going, what's the purpose, which hospital, which state, and how much time. So even I-94 might give you 180 days, but if annotation says 3 months, you should stick with that and stay with the same state. Now, some people ask me question whether we can travel. So my answer is you can land anywhere as long as you are going for the final destination, because each city does not have international airport. So you can land in Chicago or JFK, and you can go to Texas or whichever state you are going city, as long as your final destination is as per annotation. Sometimes people ask question, what if I have another letter and show to the immigration officer? You should not do it, because that will show that you are not respecting what's written on the visa stamp. So that can annoy the immigration officer, that it's clearly written state of Texas for 1 month, why you are bringing another letter. So I will say do not do that. Respect what did you write in your DS-160, what did you say in your interview, and what is on annotation. Be very careful, because many J1 visas have been denied last year, and hope this year will be better, but stick with the annotation. You can travel if you have a brother or sister in a different city. You can travel, but make sure you travel very short period of time.
Thank you. Thank you, Dr. Fateh Shahzad and Furqan. Next question is from Bushra Rahman. If paid research position on J1 visa is subjected to 2-year rule, then is it possible to shift from J1 research visa to J1 clinical visa if get match?
Yes, it is possible. Keep in mind that J1 research is limited to, I believe, 5, and J1 5 years, and clinical to 7 years. But yes, I have several of my clients. I have seen that them do that with success, to go from research to clinical, and it's not actually a change of status that you file, because you're basically just transferring your DS 2019 from one program to another program.
Great. The next question is from Varda Iqbal. For J1 visa interview, what should I say about work authorization for my spouse who will be on the J2 with a kid if he does not want to work initially? Also, when one will apply for J2 work authorization?
Yeah, I mean, so work authorization for the spouse is not required. You don't have to apply for work authorization. One thing to note on the work authorization for the spouse is that when you're applying for that work authorization, you have to be able to prove that you're not earning money to help support the J1 visa applicant. But back to your specific question, you can it's perfectly fine for your spouse or you to explain that my spouse is not going to be working. There's nothing wrong with that. There's no expectation that your spouse works. And so to your second question, which is also when will I apply for J2 work authorization, you cannot apply until you enter the United States. So once the J2 visa applicant enters the United States and is granted the I-94, at that point you can apply for work authorization as soon as you land, day one. So it's done on form I-765. There's a fee that attaches. It's about $520. Unless you apply online, then it becomes about, I think, $470. And then usually applications get approved within a couple months.
Great. So the next question is from Zoha Arshad. Hello, I met in a program and I am J1 requiring candidate. My husband is starting his PhD in China in July. He has a valid B1, B2 with multiple entries. He will only visit me for 2 to 3 months in a year. Would you advise to apply for his J2 or let him just visit US on B1, B2 visa?
So one thing to keep in mind is that if the person applies for a J2, they suddenly get the 2-year home residency requirement attached to them. So if they want to avoid that 2-year home residency requirement, then stick with the B1, B2. The B2 allows you to come to the United States temporarily, even if it is to visit somebody who's not a U.S. citizen or permanent resident. If they want to come here to visit their spouse who's on J1, I see that happen all the time. There's nothing wrong with that. So I would say if you want to do the J2, it's usually because you want to stay in the United States beyond 6 months. You want to stay united with your spouse for as long as they're on J1. But if you're only coming for 2 or 3 months in a year, then it's perfectly fine to enter as a visitor on B visa, and then come and go in that manner. So I would say don't apply for the J2 unless you're planning on staying in the United States beyond the 6-month period. But also I want to say that if you come on a B2 and then try and change your status to J2, that can be very tricky. Although it may get approved by USCIS, if you then go back to back abroad to go for stamping, oftentimes consular officials view that change of status very negatively. They say you entered as a visitor when you had the preconceived intent of applying for a J2. Why did you change your status? Why didn't you come back and apply for stamping abroad? And so you have to be mindful of that as well. So if your ultimate objective is to get J2, the more conservative approach is to go for stamping abroad rather than doing the change of status.
Thank you. Thank you for clarity, Furqan. The next question is from Sapna Sangeet. Her question is, I'm a Pakistani citizen and Canadian permanent resident. I have applied for son from Canada. Do I need to show additional strong ties to Canada at the time of J1 visa interview? My family is a Canadian citizen and lives in Canada.
Yeah, so for non-immigrant intent purposes, one thing to note is that it doesn't have to be the country for which you're a citizen. You just have to prove you have a residence abroad, that you have ties abroad. So even if your permanent residence is in Canada, you can establish Canadian ties. It doesn't have to be ties to Pakistan. What's SON?
Statement of need.
Okay.
Yeah, which you can get from if your last permanent legal residence is in Canada or any other country, then you will need statement of need from that country. If you're living in Canada for 1 year and that's your legal status, not as a visit visa or student visa, then you cannot get a statement of need from Pakistan or any other country. That will come from the country of your last legal residence.
Thank you for clarity. Thank you for clarity, Dr. Fateh Shahzad and Furqan. So the next question is from Dr. Habib Mashuri. Sir Furqan, I think that's addressing the attorney. It would be great if you can share a list of documents we can take for J1 residency visa interview to show ties. What is the ideal answer to give when they ask what the purpose of visit to US for J1 clinical? Can we mention the word residency or should it say training program?
Okay, so in terms of the first question, which is giving examples of how to show ties. So Dr. Furqan, you're in a chat with them, like a WhatsApp group, right? Is that right?
Yeah.
That's correct.
Okay. All right. So I can share the cloud link with you, and then you can forward that link in that chat. So I'll share that with you at the end of today's presentation.
Sounds good.
Yeah. And we did share in our H1 J1 visa group, and we couple of people had interview. Actually, they've been very kind and nice. They did not even put their visa in AP for social media vetting. the person got approved right there. And so they usually ask for DS 2019. Then there is a letter, welcome letter from ECFMG and tell you should carry that. Your DS 160 confirmation page, your appointment letter, which will be issued by the embassy. So those are the things, 2x2 picture, of course, your passport. If it's J2, you should have a marriage certificate, nikah nama, and some pictures, printed pictures. If it is kids, then you should carry their birth certificate having both parents' name. So, and if you do have family member, try to get a group interview. That's helpful. That you're all going together. And sometimes kids are exempted, but it's better you take your kids with you if you're going for J2 with your spouse and children.
Thank you. Thank you.
Steve also asks, what's the idea? Should we mention the word residency or should we say training program? They know it's a training program. Every J1 is a training program. So you don't have to be apprehensive about mentioning the training program or residency. You can be forthcoming about that. You don't have to worry about that.
Most of the time they ask you, how did you find this position? How did you match? Just be truthful, be simple. Don't go in detail. They know if it is coming from J1 residency, they know what's the purpose, who is going to support. So they're simple questions they do ask. And how did you find it? What you do here? When you finish your residency, what's your plan? That's a very tricky question because you're a non-immigrant visa. So what you should say that what's your plan? Say, I will try to do my fellowship if you plan to do. And as I finish my residency, because 2-year home residency applies to my case and my dependent, so we will like to follow that rule. But at the same time, you want to give, because there is a significant deficiency of physician in US. So you want to give them a little bit that I will also try to get, if I can get J1 waiver or any other situation where I can work underserved area, I would love to serve the US healthcare system. So that kind of gives impression to the officer that you have intention to follow the rule as well as, you want to serve the US healthcare system where there's a deficiency of physicians, especially in underserved areas.
Thank you, Dr. Fateh Shahzad and Furqan. The next question is from Musab Nafis. If I have written one state in my DS 160 B1 B2, but before interview I managed to get observership letter from 2 more states, so now I have to tell the officer that my plan is now to give 3 different states, to go to 3 different states, right?
Yeah. So the officer, you cannot update the DS 160 once you've submitted it; it becomes locked. But the officer has the DS 160 in front of them, and they can update the DS 160 at the time of the interview. So if you want to make changes to the DS 160, like the ones you've described here, you can do that at the time of the interview, and the officer can update it.
Thank you. The next question.
It's better to tell the visa officer during interview than becoming those letters for the immigration officer. So if you're only 1 letter, they might give you visa for 1 month. If you have 3 letters, they might give you visa for 3-4 months. So it's good to show visa officer that at that time I had only 1 letter. Now I have 3 more letters, 2 more letters. Try not to show anything more than 4 months because that becomes longer stay.
That's great. Thank you, Dr. Fateh Shahzad and Furqan. The next question is from Taha. If there is no annotation except observership written on my visa, do I still have to show same letter at immigration that I use in consulate, or I can show some other letter?
So while it may not be annotated at the bottom of the visa, it's still in your file. And so I wouldn't just assume that they don't know where you're going to be going, because they do have a record of that, and there are notes that are taken by the consular official, and all of the port of entry officer has visibility on those notes as well. So I would caution you against deviating from that.
Taha is also asking a follow-up. Yeah, go ahead, Dr. Fateh Shahzad. Sorry, I interrupt you.
No, I agree with that 100%. They have the access. Whatever you did say in interview, they're recording, and they can look at the recording and the documents you produce during a visa interview and with the DS 160, they have access to it. So do not deviate. just show only one. Only place you can deviate is the visa officer. If you have DS-161 letter or 1 month request, you can ask for more. You can show more letter, ask for longer duration. But once you're done with your visa interview, then don't change anything.
And he's also asking for clarity, Taha. He's saying, when I got visa, it was for March observership in California. Now I'm flying in June for Atlanta to take my step 3 and observership in Atlanta as well as other states until October.
So when I got the visa, it was for match observership in California.
Yeah.
Now I'm flying in June for Atlanta to take step 3 and observership in Atlanta. I think it is questionable, and I think it's risky. It may be the case that you achieve all of this and without any issues. That could certainly happen. But I just think that you have to be mindful of the fact that when you arrive at the port of entry, and if you are taken into secondary and you're asked questions about this, and you explain that now you're going to Atlanta for step 3 and observership in Atlanta, as well as other states until October, I think all of that could be problematic, and it could result in them not allowing you entry to the United States.
Thank you for the clarity, Furqan. The next question is from Sayeda Hafsa Qadri. Thank you for the session. I wanted to ask if it's better for someone in final year of medical school to apply for B1, B2 with family, parents, younger sister in school for the purpose of visiting sisters in US versus applying one on the basis of rotation, elective, observership. Which one has a better chance of acceptance? And in the latter case, should parents and the school-going sister apply separately? Thanks.
It's hard for me to say like which one has a better chance of acceptance, because like I said, there's really a lot of times no rhyme or reason to it. But you know, B1, B2 visas based on visiting families members, those get denied all the time. So it's not as though that's necessarily stronger than one based on rotation, election, and observership. But I mean, like, I don't know, Dr. Fateh probably has more experience with this because he encounters this on a daily basis. So I don't know. What do you think? Do you have,
I think, as you said, B1 can be denied for any reason or no reason, but having an elective letter and then having a letter from your dean of medical school that you're enrolled in a medical program, your exam is next year or next month or 6 months, that creates a good tie that you are a final year student, you will come back and finish your education, and you're going for something which is related, which might help you improve your clinical skills. So elective with the letter from preceptor, preferably a university program with a residency program, because most of American medical students do rotate through their medical schools and residency programs. So if you get elective in a clinic with a primary physician like myself, it's not going to be helpful. So elective while you're a student, with letter from dean that you are a student and you will have exam coming this date, and then elective letter, acceptance letter from a university program with a medical university college or medical college with residency program. So those are key factors.
Great. Thank you, Dr. Fateh Shahzad and Furqan. We are almost at the end of 1 hour period. Is it okay if I because we keep getting questions, so is it okay, Furqan, if you are available, and Dr. Fateh Shahzad and Dr. Samina Qureshi, if you continue helping our residency training applicants?
So if our panelists are okay, I'm more than happy to continue. Okay, wonderful. So let's continue, Dr. Furqan, with your questions.
Thank you very much for being generous with your time, Furqan and Dr. Fateh Shahzad and Dr. Samina Qureshi. So the next question is from Taha. When I got visa, it was... No, sorry. I think... TA. The next question is from TA. For my B1, B2 DS-160 application, I mentioned 1 month of observership in month of February 2025. But due to some reasons, I could not fly at that time. Later, I went for another observership in the month of June 2025 and I stayed there for 4 months. There was no annotation on my visa regarding a specific state. Will it cause any problem to me for my J1 interview?
I don't think it would. It could, but I don't think that it would. I generally have not seen J1 denied for that reason. But I think that if you simply explain what were the reasons that you couldn't fly at that time, if you can establish that it was due to exceptional circumstances beyond your control, then I would not expect that the immigration officer would deny your J1 visa based on something that trivial. But it may come up, so you should certainly be ready to discuss that and explain why it was that you couldn't fly at that time. You don't want to say something like I just didn't feel like it or something that was trivial. You want to make sure that it was something that was exceptional.
Yeah. And also keep proof of if you did book ticket for February, then keep the record of cancellation of that ticket. That will show that you had intent to travel, but you could not travel. Family emergency, any emergency can happen. So we're all human. It's possible. The second part that you should be prepared is that, okay, when you went there, where did you do your observership? So make a list of with the chronological order. From March this to this, I was in Colorado. From April this to I was in New York. So make a list of where did you do, what was the location, who was the preceptor. Make a list of those and how you financially supported yourself. Because if you're staying longer time, the officer might think that you were working and making money, earning money. So if you took money with you or you got money from family member from abroad or from US, keep those records that you did borrow money or you took money with you. So the officer will not think that you were staying longer time and you were working there and making money.
Thank you, Dr. Fateh Shahzad and Furqan. The next question is from Nuruline. I visited USA in 2025 in my DS 160. I asked for 1 month stay as I had one observership planned at that time, but then I got more and I even gave my step 2 while staying in the US, so I was there for 6 months.
Okay, so I think the question is whether or not that is problematic. So when you enter the United States, you're generally by default given a 6-month entry, even though you may have asked for a 1-month visa. Oftentimes it's very common they'll give you a visa for longer than what you actually asked for. Sometimes they'll give it for 6 months and a year or a year. But what that means is that you have to enter during that time, and then once you enter, you get the 6-month I-94. So back to your question, and I gave my step 2 while staying in the United States, so I was there for 6 months. I don't think that would be a problem. I've never seen that be a problem. You basically sat for an exam as well, I think, as well as doing your observership. So I mean, I would not expect that to be a problem. I have never seen that to be a problem, but I don't know. Have you?
Yeah, I think she is asking for a follow-up question as well. So I will add on the next line. Would that be a problem for my J1 visa application? I also gave step 3 this year and it stayed for nearly 2 months. Thus, I have total 8 months stay in the US over 2 years at B1, B2. I think that adds clarity.
Yeah, so I mean, staying for 8 months is not necessarily a problem. You generally want to spend a majority of your time outside the United States. So it sounds like that's 8 months over a 2-year, rather over 2 trips. So that by itself doesn't necessarily raise red flags that I've seen. But yeah, I mean, entering as a visitor and sitting for an exam is fine as long as you haven't tried to change your status from within the United States. So I don't think that's necessarily a problem that I've encountered.
Thank you, Furqan. The next question is, yeah, go ahead, Dr. Fateh.
Yeah, as from last year, 8-month might become a problem. Be prepared for being asked. They will ask because last year one applicant who went for J1, he stayed almost 18 months in 2 years or 3 years. So they denied his visa. Not only denied, he revoked their multiple entry B1. So that can be problematic. But if you're prepared, as I said earlier, what did you do during that time? First of all, you can simply say that, I was following my I-94 record, which is usually 180 days. Second, what did you do? Write it on chronological order. and how you supported financially. If you're prepared with those questions, and if you even get your visa denied, which did happen last year, but second time when they applied, the visas were granted, at least in Pakistan. But India, 270 visas said they were denied, they stayed denied because of overstay, not over than one I-94 record, just more than what they requested in their DS-160. So that is a new norm nowadays, that they do ask you if you can satisfy the visa officer that you did not work there. Of course, somebody staying 18 months, that they will raise question that maybe he or she was working there and making money. And there's really no need to stay that long. You need 3 letters of recommendation, which is 3 months. You need 1 more month for maybe step 3 exam. So I usually recommend 4 to 5 months for future. Now, what you have already done, you can't change it. It's on your record. So you should be just be prepared that you will be asked this question, and be honest and be ignorant that I was just following I-94 record and that allowed me to 180 days. I did not stay more than 180 days. In future, I will follow all the rules and have those things, what you did there and how you sponsor yourself financially.
So if I may interrupt for a second, I'd request everyone, all of the attendees, to kindly put your questions in the Q&A panel section, because we are able to access these even after the session and utilize them for future webinars. If you keep doing it in the chat and we don't get to you, we have no way of accessing them after the session. So please continue, Dr. Furqan.
Yeah, thank you for adding it, Dr. Qureshi. So the next question is anonymous attendee. Is it advisable to change the status in US from F2 to J1, or you should go back and get stamped?
Okay, so this question is actually distinct from what I was mentioning earlier, which is entering as a visitor and then changing status. Now, this I have not. This is a stronger case because you're here on a dependent visa, F2, and if you change your status to J1, I have seen those get approved historically without incident. Now, when you change your status from F2 to J1, on F2 that's a dependent student visa, so you're going to have a dependent I-20. When you do that, you're going to need to get the DS 2019 for the purposes of the J1 change of status. It's done on form I-539. That application can be filed online as well. And then you have to prove all the same things that you would prove if you were to apply for the J1 from abroad. So is it advisable to change status? It can be done. I haven't seen one denied. And if in the future you wanted to go for J1 stamping, I would not expect that would be a negative factor in your case. So it's something that you should certainly consider if you want to apply, as opposed to going for stamping abroad.
Yeah. I would like to add a little bit. So it also depends on if the ECFMG issue you DS 2019, because last year they were issuing to B1 as well as J2 visa holder, but year before they were not issuing to J2, especially if there was 2-year home residency requirement. Similarly, B1, they were not issuing DS 2019. They were asking the applicant to show exit record. So you have to get an exit stamp or I-94 showing that you have left the country before DS 2019 was issued. So if ECFMG does not issue you 2019, of course you cannot change your category from F2 or J2 or B1 to J1. Now, I usually recommend people, if you can go, especially these days in Pakistan, they're issuing visas J1 without any problem. Things can change. Political situations are very favorable. So we should try to get visa stamped. So in future, you might have to travel for any family emergency. So you will have a stamped visa. So then you can easily go and come back. But if you don't, then you will have to, sometime the waiting period is 3 months, 6 months, depending on, Karachi is closed now, so the waiting period can get longer or shorter. So right now, because we share all your information with the embassy, so you kind of kosher that, you're a genuine candidate. So chances of getting J1 is good right now. And I will highly recommend, if you can go travel, you should get your visa stamped.
Great. Thank you. Thank you very much, Dr. Fateh Shahzad and Furqan. The next question is from Syed. I was previously issued an SSN while working on an unpaid position at the Mayo Clinic in Rochester. Do I need to mention the same SSN while filing out my DS-160? What do I need to mention in the taxpayer ID because I was never issued one? Lastly, what are the different options we have that we can mention in additional contact information while filing DS-160?
Okay, so with respect to the SSN question, your SSN never expires. It doesn't change. So you need to mention that SSN on the DS-160 application. The SSN is not the taxpayer identification number, also known as the TIN number. So the SSN does not need to be mentioned in that section. It just needs to be mentioned in the SSN portion. So you can mark that as not applicable. A taxpayer identification number is for people who may not have work authorization but still want to file their taxes, so they can apply for a TIN number, TIN number, and then they can mention that there. So sometimes people have TIN numbers. It's more common for spouses who don't have work authorization or children who don't have work authorization but want to file their taxes. Then they can get a TIN number for the purposes of filing with the IRS. So if you have the SSN, then that's great. You're not going to have a need for a TIN number, and you won't have a TIN number, so you can mark that as not applicable. And then the last question was, what are the different options we have that we can mention in additional contact information while filing DS-160? I don't quite understand the question when you mean like different options. I mean, there is a section of the DS-160 that asks about contact information in the United States. And normally, you can mention if you're coming to the United States for the purposes of rotations, or if it's sponsored, you can mention your sponsor, the actual program sponsor in that section. If you're coming to for the purposes of visiting family, then you would mention the family member here in the United States that you're coming to visit, and you can mention their name, their address, and their email and their phone.
Great. Thank you. The next question is Amar. Can you please tell how early can I enter the US on my J1 visa? My program start date is July 1st, but ECSMG portal, my TPL has initiated my J1 application from June 16, which is the orientation day. I'm also scheduled for health screening by my program on June 8. Can I mention an early June date, like June 6 in my DS-160 as my arrival date?
So no earlier than 30 days is the rule. So
Great.
It's a 30-day hard and fast rule. So that's the earliest you could enter.
But if your program requires, it's a requirement, and you have an email or a letter that you're supposed to be here 8, so your 30-day will start from that day when you are required to come to join the program. So it's okay to come before June 1st, which is 30 days as per DS 2019. But as long as you have a letter or email from your program that you're required to come, then you can put that date. In this case, 8 June is good enough. You can come anything 2 weeks before June 8th.
Thank you. Thank you very much, Dr. Fadeshazad and Furqan. The next question is from Maheen. Hello, I have stayed for 6 months in the US when I took my Step 2 exam and 6 months when I took my Step 3 exam. That is a total of 12 months in the last 2 years. This led to rejection of my B1, B2 visa renewal. How should I show non-immigrant intent during my J1 visa interview?
All right. So that's not surprising that it led to a rejection of your B1, B2 visa renewal, because pretty heavy amount of time inside the United States in a 2-year period. But to your question, how should I show non-immigrant intent during my J1 visa interview? So I'm just going to kind of repeat some of the things that I mentioned during my presentation. There are 4 factors that the U.S. Embassy looks at. The first one is family members. So they'll be looking at whether or not you have, for example, elderly parents that you need to return to, that you need to take care of, or spouse or children. The second thing they look at is employment. If you have ongoing employment, you'll want to present a letter from your employer that explains that you are given a leave of absence, and that once you return to the United States, the job will be open to you. Excuse me. The third requirement is that, or the third option that they can also consider is financial ties. So if you have investments or if you have bank accounts, they can look at that too. And then the fourth thing that they can look at are property ties. So if you have titles or deeds to land, and sometimes they'll even consider the property of your parents, but normally it's going to be property in your name. So those are all factors that they can consider. And again, I have a more exhaustive list that I'm going to share that's going to be shared in the groups. And then that way you can use that as additional help and guide in terms of establishing non-immigrant intent.
Can I add a little bit more?
Yes, please.
Yeah. So I think her question specifically was for future J1. So J1 is non-immigrant intent, and 2-year home residency kind of forces you to be non-immigrant. So if you did not try while you're in US, try to get engaged or get married, or try to seek job, or try to seek any asylum, that should be okay. But as we mentioned earlier, you stayed longer than you should have stayed. So you be prepared for asking questions. J1 might be refused, but try it again 1-2 weeks later. Be prepared how you supported yourself financially and what exactly you did during those 12 months.
Thank you, Dr. Fateh and Furqan. The next question is from TA. I took $4,000 with me, deposited money in Bank of America, and later also borrowed money from that account from a relative who lives in the US. That bank account is still active, though I did not use it later. Will it be problematic? And what documents I should have to show that I borrowed money from my relative?
Okay, so having a bank account in the United States is not a problem in and of itself. That's pretty common. You said you took $4K with me, deposited money in Bank of America, and then borrowed money. So the person that you borrowed money from there should be a letter from that person that explains that they donate or they gifted you that money, or that they're lending you that money. And then that same person who authors that letter should explain where they got the money from, because they have to have established the source of those funds, because U.S. Embassy wants to make sure that you didn't obtain that money through criminal means. And so you want to make sure that those sources, that there's a paper trail, that it's fully documented. And so that's what I would say with respect to the money that was loaned to you. And then in terms of the money, when you say I took $4K with me, I'm assuming that's cash that you then deposited into your Bank of America. So again, even though it's cash, you still have to be able to prove where you obtained that cash from. So if it's from your employment, that's fine. You should have employment verification letter from your employer. If you earned that money through let's say investments, or let's say inheritance, again, all of that has to be fully documented, and you have to be prepared to present that evidence in case they want to see that evidence. So again, to your question, will it be problematic to have a bank account? No, but you still have to prove where the transactions are coming from, because this is very common for consular officials to be able to kind of go line by line with a fine-tooth comb to see where these transactions are coming from, and you have to be able to document that.
Yeah.
Yes, go ahead, Dr.
Get statement from the person you borrow money from for that period of time, that he had funds and what was the source of fund. Doctor, as Mr. Furqan mentioned, so source of the person who gave you money, and then the trail showing in bank statement that it was transferred via check or via Zelle or whichever way from his account to your account, and then statement of your account showing that you received that money at that time. And if you took $4,000 and you disclose your money on immigration, which you're supposed to, that will be plus. Otherwise, you will have to show the proof where did you earn that money in Pakistan.
Great, thank you for clarity, Dr. Fateh Shahzad. The next question is referred to Dr. Fateh Shahzad. Any update on Karachi Embassy for J1 visa interviews?
As of now, they're not issuing J1, but I was kind of informed that hopefully after the recent coming visit, which is most likely Monday from high official from US, they will open maybe by 20th, 21st, or after 21st. Hopefully ceasefire comes in effect. So expect after 21st. Right now, Islamabad is giving visa interview dates within a week. And if you don't get it within a week, you can ask for emergency, but emergency should be 30 to 45 days before your arrival date, which can be your orientation date, which can be start of your residency. So don't apply more than 45 days, then it does not become emergency. And this emergency will not be medical, although our profession is medical, but don't mark medical, but still mark business, and request the reason, and then attach that email or letter from your program that you're required to join June 8th or June 15th, and of course DS 2019. Within 24 to 48 hours, you will be given a denial or acceptance letter for notice for your emergency request, and you can re-request if it's denied. But if you get your emergency request accepted and you don't show up for visa interview for that date, then you cannot reapply for emergency for 1 year.
Great. Thank you for clarity, Dr. Fateh Shahzad and Furqan. Let me ask the next question is referred by Dr. Samina Qureshi from a participant. During my observership, I did not open bank account and use my spouse's bank cards and some USD dollar cash for expenses. Will it be a problem for me at the time of J1 visa interview?
Not necessary for you to open a bank account. I mean, that's fine. The money that your spouse has is not exclusively your spouse's money. The United States considers that joint money. If you use, if the transactions flow through your spouse's bank account, that's not necessarily a red flag. So I wouldn't be concerned about that.
Just to be extra careful, get a letter from your spouse that she let you use her credit card with consent and permission. So that will be good.
Okay, that's great. That's fantastic. Thank you. Thank you very much. The next, we have Furqan, Dr. Zishan. He's a board of director of APPNA. He has a quick question. If you can allow him to ask question, can we unmute Dr. Samina Qureshi, Dr. Zishan, Muhammad Zishan?
Sure. 1 second. Let me see where I can find him.
He has a question regarding.
Yeah, go ahead, please, Dr. Zishan.
Well, thank you so much, first of all, for such a discussion. I mean, I cannot even imagine how much it have been helpful. So thank you to everyone. So I'm a child psychiatrist based in New Jersey, and many times I offer observership to many residency applicants. So one is a lot of people ask about observership letter. So any suggestion or guidance as a preceptor, because sometimes, unfortunately, we have incident where people don't show up to the observership. And in case if we get a call, I have not yet, in case if we get a call and if that person is not here, how we respond. The second question is if something happened to that student during the observership, is there any insurance that we suggest to these applicants so that they have it? Thank you.
Thank you, Dr. Zishan.
Yeah. So with respect to your first question, which is that if you sponsor somebody for an observership and then that person fails to appear for their observership, I think your question is whether or not any liability attaches to you. And that answer is no. No liability would attach to you. That's not any fault of your own. So although I would suspect that the embassy is probably keeping track of something like that. So it may mean that you might be less likely to be approved for observership in the future. But if is there liability necessarily that attaches to you? No, you're not going to be financially liable or criminally liable or civilly liable or anything like that. And then I think the second question, remind me, what was the second question?
The second question is if something happens.
Insurance.
Yes, thank you.
Right?
Thank you.
Insurance. Okay. I really don't know about that. I don't know, Dr. Fateh, do you have any insight on insurance?
Sure. Couple of things. First part I will add because recently few things happened. So I will give you like a living experience that one of the preceptor wrote that they will be providing accommodation and food free of cost. So that visa was denied. So be careful when you write that. If you are providing that service, that's great, but don't write on a letter. And second thing is that the letter should have these contents, that name and possibly passport number and date of birth of that individual, then the preceptor name, and that should be date and location, and then it should be on a letterhead, not an email. They don't accept email these days. So these are your first question. Second, you should recommend them to take traveler insurance if they do, because one incident happened. One girl was doing observership. She had hepatic liver failure, acute failure, and every one of you or most of you know that. So it was a problem because she did not have insurance and she did need a liver transplant. So traveler insurance you can recommend, but it's not your liability. Now, if something happened while they're here on your clinic or in the hospital, that your homeowner insurance should cover that injury, or your liability insurance should cover like an employee. I don't know if they will honor that because most of these people don't have social security number. So I will recommend that they should carry or have a traveler insurance. And we one time we thought about getting that traveler insurance from APPNA standpoint, but it's not possible. Financial cost is too high, and people who can afford will be asking us to do that. So as a preceptor, I will say you should recommend highly in your letter that they should have in your communication with them, not the visa letter. You should say that they should get traveler insurance. But again, it's not your liability. And if they don't show up and the embassy or somebody does communicate with you, be truthful if they did not show up. Because I know there are few doctors who've been blacklisted. Their letters are not accepted anymore because first they were charging people just for letter, and they were issuing hundreds of letters. So in 12-month period, how many people you can have shadowing you? You can't have 100 people shadowing you. So because they were getting $2,000 per letter, so they were issuing right and left. So they were blacklisted. So their letters are not accepted anymore. So just be mindful of those things.
And Dr. Fateh, if I may ask, sorry again,
Yes.
thank you so much. The liability insurance, so we ask about with our the owner insurance, they don't cover if anything happened from a patient to that student. So anything we suggest to those students along with the travel insurance, any liability, not liability, I don't know what that insurance would be. So, yeah, if you can advise.
Yeah.
Thank you.
As long as you have a clear understanding with them that they will not share the information, it should be something signed. HIPAA should not be violated, and they are not going to touch the patient. So you do not have a liability based on patient because they're not going to make any decision. They're not going to write any prescriptions. They're not going to touch physically patient. So there's no harm to the patient on their behalf. And they don't have social security number, so they can't be even included in the lawsuit, my understanding. But for electives, because they do have inpatient, they do touch patients, they do examine patients, they do write on the charts, then most of the universities do require them to have, or they include in their liability insurance, because the medical student of US medical schools are covered in that insurance. So the hospital universities do have that umbrella, but private doctors don't have it.
Thank you.
Yeah, especially for observers.
Thank you, Dr. Jishan, Dr. Fateh Shahzad, and Furqan. The next question is from TA. My sponsor was my mother, who was government employee. I had the affidavit of sponsorship from her at that time. So should I have another affidavit stating that my mother was my sponsor for the previous visit, or it should be some other document?
So I have to kind of okay. So my sponsor was my mother. So I think TA is talking about a visit visa, perhaps. So if the TA is talking about a visit visa, it's not necessary to get another affidavit proving that your previous sponsor was your sponsor. That will already be part of your file, which they can view. Your new evidence should be specific to the existing visit visa application that you're filing for. So it's not necessary to refer to a previous visit visa application on your new visit visa application. That's only going to be confusing for the immigration officer. So just try and keep it simple. Stick to the specific purpose of your visit visa application. They already know who your previous sponsors are. They can view all that in your history.
That's great. Thank you.
So just to remind everyone before we go any further, we're an hour and a half into the session. So Mr. Furqan, do you have a hard stop? We could conclude by a couple of more questions, or how's your time look?
Yeah, let's do a couple more.
Okay, so Dr. Fateh, are you okay?
I'm okay till we do 2 hours. It will take 2 hours. Yeah.
Okay, so let's do a sharp stop at 2 hours, which is in 30 more minutes. So Dr. Furqan, I would advise to time the questions such that we finish after 30 minutes.
Yeah. Thank you for being generous with your time, gentlemen, and Dr. Samina Qureshi, Dr. Fateh Shahzad, and Furqan. The next question is from Nouri. Do this letter of support have to be an official stamp paper, or can it be a plain note by our financial supporter?
Letters of support. So I'm assuming that that Nouri is referring to a financial sponsor. If you're referring to a financial sponsor, then you generally want to get something like that attested. Here in the United States, you would call it notarized. I think in Pakistan they call it attested. This is a specific sort of bond paper that they would use, and then it would be stamped by what would be the counterpart to a notary here in the United States. So that's what I would encourage the financial sponsor to do. In addition to that, they're also going to want to include evidence of their financial solvency, which is going to include things like their bank statements. It's going to include things like their investments, things that can be liquidated. That's going to be important if they're going to be the financial sponsor.
Thank you. Thank you very much, Furqan. The next question is from Abdur Rahman.
Can I add one thing to that?
Yes, go ahead.
The sponsor is an employee, like your dad, your mom, somebody has a steady source of income, rental income, retirement income. So there should be proof of that too. That, okay, they have 5,000 rupees or 1 million rupees in their account, but where is that money coming from? Is just from their previous saving, or if they're actively getting money? If they're getting active money from any source, so they need to provide that source also. Letter from their employer, or retirement, some kind of proof, as well as sometimes they ask their tax return, because that will show that they have income this year or last year.
Thank you. Thank you very much. The next question is from Abdur Rahman. I came to the US on a J1 research, but because of how busy my program is, I could not go back to get a restamp. I will switch to a J1 clinical and want to go back to Pakistan during residency. My visa will have been expired for 15 months by that time, but valid I-94TS2019S. Will a change in category and an expired visa for 15 months by that time make the visa officer consider rejecting my J1 re-stamping?
I haven't seen that to be the case. Just because your visa has been expired for 15 months, that by itself is not necessarily a red flag, because J1s are typically longer in duration as it is. So the fact that there's no expectation that just because your visa is expired, you have to go back and get your visa re-stamped, because like I said during the presentation, your status is controlled by your CVIS record. So as long as you have active DS 2019s, that's not a problem. You have to think of the visa in your passport as an entry document. It's kind of like it's like if you want to go into a club, you have to have some sort of document that gives you entry and once you're there, then your status is not controlled by that entry document. It's controlled by your DS 2019 and your CVIS record. So back to your question, the fact that the visa has been expired for 15 months, that in and of itself is not a problem. And the fact that you switched your program from clinical, or rather that you switched it from, I think, clinical to research to clinical.
Research to clinical.
Research to clinical. That's super common. That's not going to be something that the officer is going to be surprised by. That's pretty typical. So that also is not necessarily a red flag.
Thank you. The next question is from Uswa. I stayed for 4 months free of cost with a friend for an observership and step 3. Would it be an issue?
So I'm assuming that this person did so on a visit visa. As long as that's consistent with what was stated at the interview, then that shouldn't be a problem. But if you stated something differently at the interview, then it could potentially be a problem. But if you were transparent about that at the time of the interview, then I don't see why that would be an issue.
Thank you. Thank you, Furkan. The next question is from Zain and referred to Dr. Fateh Shahzad. The question is, I have a question for Dr. Fateh. For previous B1, B2 visa application, an applicant did not mention an extended family relative in the US under the other relative section, mainly due to a limited contact and not realizing it should be included. During travel, the applicant verbally clarified to the officer that there was no immediate relative, but there was an aunt in the US citizen. Now, for an upcoming J1, J2, DS160, would it be better to include that relative for full transparency, or could this create concerns due to the earlier omission, or the discrepancy between two DS160 will be a problem? That was a long question, though.
Sure, no, that's a very common question. So the immediate family is your first degree blood relative, your brother, your sister, your parents, or your kids, or your spouse. So if distant relative, there is really no word for khala, mamu, puppa, pupa in English language. So those are all aunts. So you don't have to mention that. If you did not mention, you don't have to include now, because that will be discrepancy. But if Furkan has different viewpoint, I will welcome that.
So there's what's called a material misrepresentation and an immaterial misrepresentation. A material representation is one that goes to the very heart of your application that affects eligibility. Something like this is pretty immaterial. It's not something that the U.S. Embassy official will necessarily really harp on, because it's not really central to the purpose of your visa. So whether your aunt is in the United States, oftentimes you don't know what you're not expected to know what your aunt's immigration status is. So it's probably better to stay consistent, and I would agree with Dr. Fateh on that matter. It's probably better to stay consistent, because again, it's not really material to the heart of your claim, the heart of your visa application.
Good answer. Thank you. The next question is from Habib Mashuri. Can we take our parents' bank statement and wire transaction receipt of USD transfer to show proof of funding during rotation period of stay?
Yeah, you can do that, but again, you need the actual letter from your parents as well, and you need your birth certificate. And as Dr. Fateh said, that birth certificate, oftentimes birth certificates don't list both parents' names. So like if you get it from the hospital, it may only list the mother's name or the father's name. So you should get it from the Union Council or the Nadra office or something like that, where it lists both parents' names. That way you can establish the parent-child relationship. But yeah, that's those sort of source documents are going to be important. Bank transfers, wire transactions, all of that is going to be critical in terms of proving the source of the funds.
So thank you very much. The next question is from Dr. Hussain. Hello, I have an interview on the 26th of May. However, my program wants me to be in the US by 12th of May. Orientation on June 10th. Can I still apply for emergency right now, as it's more than 4 weeks from my orientation right now?
What do you think?
I will not recommend that, because you have enough time. And the program requirement does not mean you have to join it. You're obligated to join by July 1st, even later. So I will not recommend it. Clogs up the system. You deny it, then I've seen people who got their interview in May. They requested the emergency, and they was given in June. So don't do that. You're good enough. It's only 2-3 weeks left. So go for 11th May. You have enough time to join the program by first week of June, or even later. If you miss orientation, not a big deal.
I have a quick question. I think someone said it was perhaps inadvertently skipped. Sadiq Ali is asking, can a J2 request for emergency visa?
Really no reason for J2 unless somebody health issue, or the J1 has a child who is a minor or needs a child care, that J1 needs to join by mid-June, and say somebody is needed for that purpose. You can, but it's really not an emergency. But of course, you can request whether it will be accepted or no. Nobody knows.
Yeah, there's no harm in requesting, but yeah, I think it's going to be difficult to be successful on a J2 emergency visa.
Thank you.
Thank you for catching the skip question, Dr. Qureshi. I think I need another coffee. The next question is from Maheen. One letter of recommendation from my research preceptor says about me, quote unquote, had she been able to stay in the US, I would have hired her as my research coordinator without hesitation. Is this wording problematic? I have never engaged in employment on B1, B2 visa. I want to emphasize that I bore all my financial expenses myself.
I would remove it. I don't think it's really helpful to any future application. This sort of comment is just it's a nice comment. It's certainly favorable to you, but it's not really necessary, and it plants a seed in the mind of the immigration officer, I think, that is unnecessary. So I don't think it's really going to be helpful, and I would probably encourage you to admit it.
Yeah. It's considered like a payback to the person doing their some paperwork. So similarly, I mentioned earlier that one letter stated that we will provide free residence and free food. So that was considered as a reward or payment. So it's better not to mention in the visa letter.
Great, thank you. The next question is from Anuri. Sorry, it's Sire. Let me just see. My DS 2019 for J1 unpaid research was initially from August 5th, 2024 to August 4th, 2024, which was later extended to September 14, 2025 due to ongoing research project. Does it create any sort of problem related to overstaying in the US during my J1 residency visa interview? Thank you.
Yeah, so that's pretty common for a J1 program to be extended, as long as your CVIS record was extended, as long as a new DS 2019 was issued to you for the extension, then that's not a problem. I wouldn't be concerned about that.
Great. The next question is from. Yes, go ahead, Doctor.
Just take both DS 2019, the old one and new one, just to make sure that although they might have a record on their system, but try to make the visa officer life easy. Take all the documents. So say I have my old first DS 2019, I have a second DS 2019, I have communication from my program, as well as communication from my sponsor. So as long as you have all those things, there is no issue at all.
Great, thank you, gentlemen.
I actually have to bow out at this point. I know you guys are going to go on for another 15 minutes or so. So if there's anything that comes up, certainly, send me, let me know. I'll be happy to offer my insight. And but again, I really appreciate you guys bringing me on, and I'm glad we got a chance to have this discussion.
Yeah.
Thank you, Furqan, for being graceful with your time, and I appreciate we appreciate your expertise and yes.
Yeah, so from APPNA Advocacy Committee, thank you so much, Mr. Furqan. We will be sure and share your best contact email if someone wants to follow up with you. So again, thank you so much for your time.
Yeah, absolutely. Enjoy the weekend, everyone. So long. Good office.
Good office.
Good office. So the next question is from Fizza. I'm matched into residency. I'm a J1 applicant. My parents applied to US visa residency in 2008. I'm no longer eligible, but my parents are, and they have applied for their green card. How will that affect my application? What question will they ask me during my interview, and how shall I respond?
So if the petition was filed and this person's name was included and it's still there, so the best thing is to remove that name from the petition. And good thing is that this person is aged out, so she is not eligible for immigration as a child. So she should be prepared. Maybe she can take copies of the petition with her and tell the visa officer that she has aged out. She's not eligible for that. That should be helpful. And it should not have any negative impact because her parents applied for her. She did not apply for her, and she's aged out. So it should be not a problem. But they will definitely ask question. And she should mention in DS 160 If she or somebody on her behalf did apply for immigration, she should mark it yes, even if she aged out. And then write in explanation what happened.
Okay, great. Thank you very much. The next question is from Mehreen. I took $5,000 while traveling to the US for observership last year. Do I have to take bank statement or anything as proof for financial support? Or can I just say I had this much cash to support myself in the US?
Yeah, it's legal to bring that much money. And if you have any kind of document that you revealed that, usually the visa officer or the FIA from Pakistan and the immigration officer, they do document that you brought this much money. If you did not disclose, then you should be prepared if they ask you a question, because it's illegal to bring $5,000 with you. So if they ask you brought $5,000, or they ask you how much money you brought or how you sponsored yourself, then you should be able to tell that I brought $5,000 and I told immigration officer on arrival. Or you can say, because it was not more than 10,000, I did not disclose. Both ways it's okay, because you have to disclose if it is more than 10,000, and you have to disclose in Pakistan if it is more than 5,000. So 5,000 is just the number. If she does not disclose, that's fine. If she discloses, she should tell that I did mention to the visa officer. If she has any document that she at that time that money was converted from a currency exchange person, she should bring it. She should bring his bank statement, but it's not absolutely necessary.
Great. Thank you very much, Dr. Fateh Shahzad. The next question is from Hassan. Two quick questions. First one is, can a spouse J2 bank statement be shown as person supporting J1? The next question is, if a J1 applies for EAD, can her income be more than the J1? I've heard J2 cannot support J1.
Yeah. See, the J2 is basically for emotional support and physical presence. So for certain rules apply to J1 and J2. J2, they have time, they don't have to travel with the J1 at the initial stage, but they cannot stay away for more than 1 year. Otherwise, the purpose is kind of not there. Why she or he applied for J2 if they are not going to fulfill the purpose of J2? Now, if you do come here, then you should stay at the same address. If you get EAD, you can work a little bit further, like another city, like New Jersey, New York, but you should not change your residential address. You are supposed to be staying at the same address with your spouse. You cannot stay more than 4 months away from your spouse once you enter. Otherwise, your J2 may not get approved next time. Income, J2 can earn money. J2 can earn more money than the J1. Maybe that's IT person get a job of $100,000 and J1 might be making it 60, 70,000, but you cannot be paying the bill on behalf of J1. Now, if you make money, you pay groceries, something where there is no like actual bill payment, like rent and your electric bill, and those should come from J1, not from J2. Yes, you can give a cash to J2, but there should not be any kind of documented proof. Like if J1 is spending 100,000 on their bills, on their credit card, of course they will ask questions. She was making 60,000, how she got 100,000? So you have to be very mindful that J2 cannot financially support J1. So if you go do grocery, you can do, but as long as it does not come from credit card and payments to the rent or other bills from J1, from J2 income, it's okay. So J1 should be mindful that her bill should not be, or her bank account should not be more than what her income is. So you cannot take 50,000 from your J2 and put in J1 account. J2 should keep separate account.
Great. Thank you very much, Dr. Fateh Shahzad. The next question is from Sadiq Ali, and he's asking, my wife, Pakistani citizen, applied J2 visa from Jakarta, Indonesia. She has temporary resident permit over there. Her DS 2019 is valid till June 2026. They have her passport and gave her yellow slip. What is current situation of AP processing, since her permit will also be expiring by August? When is a good time to contact the US Embassy if it's taking too long and we need our passport back? I add emergency visit later. Could you please point this as well? Thank you.
So I will say that you can ask for passport anytime. But once you ask for passport will be sent to you at a pickup location or mailed to you or the applicant. Then your AP process slows down once you get your passport. So if it's been too long, then maybe quit that, cancel that AP or cancel that visa and reapply on new DS 2019, same location or a different location.
Thank you very much, Dr. Fateh. The next question is from Hamza. Hello, my question is for Dr. Fateh Shahzad. My social media is pretty clean, but every now and then I came across anti-Israel and pro-Palestinian posts from my friend and family, though I don't engage with this post in any way. Should I concern about this?
So now the social media is very tricky. Even if you're not statement and if it's on your page, it's considered your property. So either delete it or you write on a comment, I do not agree with above message or statement, and you disagree. And anti-Semitic, we have said many times, it might have our emotional relationship with Palestinian, with Iran, with anything, but you are coming to US as on a visa, and visa is not your right. It's just like a prestige given by US Department of State. So you should be mindful that what they don't like, and anti-Semitism, favor of Hezbollah, favor of Hamas, favor of Iranian government. As I said, we might not like it, but US government as a policy does not like that kind of statement. Any kind of picture showing with somebody who is not who is on the wanted list, you should delete that, even if it's you or somebody else. So just be very, very careful. Keep looking at your social media, and even if you delete the post one day before, that's okay. That shows that you are not propagating that mindset. Just see what US looks at, that you are going to come here and maybe start pro-Palestinian, pro-Iranian, pro-Hamas kind of agitation here, like it has happened in Harvard University. It's happened in so many other universities, Columbia University is example. So that's what they want to prevent, that you should not have that kind of mindset.
Yeah, thank you. Thank you for being so detailed, Dr. Fateh Shahzad, on this important topic. Please be cognizant about it, all participants. The next question is from Alina. I did not open a bank account during my B1, B2 visit to the US and used my mom's debit card for all my transactions. She lives in the US and I asked to receive a loan from my med school in her bank account. What would that be an issue during my J1 visa interview for my residency?
Can you repeat that question? I was diverted a little bit.
Sure. I did not open a bank account during my B1, B2 visit to the US and used my mom's debit card for all my transactions. She lives in the US and asked to receive a loan from my med school in her bank account. Would that be an issue during my J1 visa interview?
No, as long as you have a documented proof and maybe a letter from your mother that she allowed you to use her credit card, and use that word that that is like a borrowed money, not like a help, because you need to be showing that you're a professional, you're a responsible person. So if she can say that she lets you borrow money through her credit card or debit card, and that's okay. And then her bank statement that she had some source of income. If you deposit loan money into her account, so loan document should be there, and then the bank statement at that time when loan was received should be there to present. That show that yes, you did have a loan, you received it in her account, which is okay, it's all legal, but you should have a document.
That's great. Thank you. Dr. The next question is from Ashish. I received money from a family friend during my visit in US and I took 4,000 money from my Pakistan as well. Do I need to explain the money that I received from that family friend?
Same answer. Have a letter from them as a loan. And if they ask you a question, what you want to do with that, say, whenever I have funds, I will return it to that person with thanks.
That's great. Thank you. Thank you, Dr. Fateh. The next question is from Sire again. Can I apply for my dependent J2 visa after a year of my residency?
Anytime.
Great. The next question is from Syed Ali Hussain. Thank you for conducting the webinar. I applied for my US B1 B2 visa from Oman as my family lives there. and I was visiting them. I have traveled twice to the US on that visa without issues, but I wanted to inquire if this will create issue for me during my J1 visa process or interview, and what kind of question I can anticipate, prepare for.
Yeah, they might ask, why did you apply? So answer will be same. I was staying with my parents legally, so I applied for. You can apply if you have a legal status there, any third country, and of course how you supported your visit to US. You did not work there, so the financial support is main thing. If you did go from Oman and you took money with them, you should take documents or statement, bank statement, or letter from your family member that they gave you money. And applying from Pakistan or any other country should not be a problem for J1.
Thank you very much. Thank you very much, Dr. Fateh Shahzad, and thank you. I think we are pretty much almost there. So I would like to have final words from Dr. Fateh Shahzad, Dr. Samina Qureshi, and I would like to share the email address and the website of our attorney, Furqan Azhar, in the message box in case you guys want to follow up in the future. So, Dr. Fateh Shahzad, you want to say any final words? And then I will give Dr. Samina Qureshi.
Sure. I thank you, Dr. Samina and Dr. Furqan. And I thank you, Dr. Zishan, for being here as a board of director member. We do appreciate. And Zishan is always available and always participates in these webinar, which is very commendable. And I also thank Dr. Baba Rao for being our president and allowing us so many webinars. And he did show his presence this earlier.
Yes.
This is on behalf of myself, and I take my resident applicant as my children on their behalf too, because ultimately we're helping them out. So for residents, applicants, the visitor, just be honest, be open. The visa officer, when you go there, if they ask you question, they know the exact answer. So try not to trick them. They cannot be tricked. That's one thing they're good at, that they do understand the body language, the facial expressions. They are trained by psychiatrists for just to looking at your body language, the way you answer the question. Be confident. As I mentioned earlier, I think in Pakistan, we should not have any problem. I'm not giving you any guarantees from APPNA standpoint, but I'm reassuring that you will get visas. If for some reason your visa goes into administrative processing, it's a required mandatory process in some cases. Fortunately, this year I was informed that they will not do mandatory AP for your social media vetting, but does not mean that your case will not go into AP. It's okay. Don't get panicked. Don't get worried about. Don't start screaming and crying like everybody else got approved. I did not. So you can be one person that might not get approved, might not get approved for the first day you go for interview, but eventually you will get visa. It's okay to be late. You don't have to. I get believe me, thousands of these messages that my program wants me to be there on June 19. Why can't I get my visa before that? It's okay. Your program cannot tell you that you have to come there. It's good to join your program on time when they want, but it's not absolutely necessary. There's no legal obligation on you to join the program as what the program wants. Even July 1st, you can't join, you can't join. People have joined in mid-July, in August, in September, in October. So I'm not saying that this is going to happen. But if it happened with one person or 2%, don't feel like that you are picked up because of your beard or because you did not wear scarf or you are wearing scarf. That's not a reason. Where there might be a reason why your visa was put on administrative process, denied. That can be merely the feeling of the visa officer. It can't be any document. It can't be the embassy policy or U.S. Department of State policy. It can be only person who's interviewing you that he or she did not feel comfortable. So this is my few things, and we will share your information, the journey information. But be mindful. You guys text me 3 o'clock in the morning. You might not get answer from them 3 o'clock in the morning, and their law. They are doing this to make money. That's their job. This is not my job. I do work as a doctor. So if they ask you for fee, you might be ready for that. because attorney might not do for free like I do. So if you ask them question, they might want you to sign a letter that you're hiring them as an attorney, because that's their legal requirement, because their advice is considered their liability. So they might ask you to sign a paper, then they might ask you to send money, then they might answer questions. So don't get disappointed that this person was on the show or on the webinar and now he's not responding. Be mindful that they have their own obligations.
Thank you. I think those are very wise words of wisdom. Dr. Furqan, go ahead with your final statement, then I'll conclude the webinar.
Oh, thank you, Dr. Samina Qureshi. First of all, thank you to you for such a wonderful share. You have been so energetic and coordinating the whole event so graciously. Dr. Fateh Shahzad, you have always been wonderful over the last several decades, and we really appreciate your services. Dr. Zishan for joining us as a board of director and being part of this webinar. And I would also like to thank Furqan for his expert opinions, and Dr. Babar Rao for providing us this platform and being there, always being with us and leading from the front. So that's pretty. Thank you all the participants for all your questions.